Welcome back, everyone, to our second plenary session of the day. Our panel will be discussing the constitutionality or unconstitutionality of religious public charter schools. Joining us as our moderator is Michael Donnelly, Vice President of the Yes Every Kid Foundation. Mike has previously served as Senior Counsel and Director of Global Outreach for the Homeschool Legal Defense Association, and an adjunct professor of government at Patrick Henry College. Before we get started, we've had so many great questions today. Just a reminder, if y'all wouldn't mind, when you ask a question, stating your name and your affiliation, it would be great for all of us to learn your names and where you're from. So Mike, with that, take it away.
Thank you, Angela. Welcome back from lunch, everyone. Wonderful to be here with you. Delighted to be with Renita and Nicole, who I will introduce more fully in a moment. But just a quick introduction about Yes. I encourage you to go back to our table, get a flyer there. We're working to transform education in this country. I don't know if you think we need to transform education in this country or not, but anyway, that's what we're about. We see a future where every family has the opportunity to choose however, wherever, whenever they want their child educated. We're good with that. A friend told me before that she gets a little discouraged coming to these things because she hears intractable problems, this is really bad, things are not going well. And I just wonder, are you discouraged about education in our country? Are you feeling discouraged? Because I'm feeling encouraged. And I want to just tell you briefly why. We just lived through a pandemic where people saw the reality of education. We can talk about learning loss. We can talk about cultural issues. We can talk about failures in schools. These are serious issues that deserve our attention. And I don't want to be Pollyannish, but I do see a bright future for education in our country because I see people getting involved like they have never before. I see people out there. I see citizens getting involved, engaged, running for school board. I see very credible public surveys from like Todd Rose at the Populist Institute saying the people are wanting something different. They want something different. They're not satisfied with what they have before them. And people are doing things differently. Like the measure of whether people are changing is whether they're changing, right? And whether you can observe it, and they are. I mean, we have the highest number of homeschoolers in the country ever. 5 million, 4 million in the last 50 years, from 0 to 5 million in 50 years or whatever. Charter schools, 30 years, from 0 to 4 million, correct me if I'm wrong, in 30 years. Private schools have grown from not 0, but pretty small, to 7-ish million. People are changing their behavior. They're not asking for permission, they're just doing it. And yeah, there are things that are in the way. We're seeing public policy changing like we haven't before, ESAs, voucher programs, tax credit programs. This past year was an amazing year of things happening in that area. And in Florida, they're reporting they're up to like 500,000 people have applied for this new universal ESA program that they have. Other states are reporting adoption as well. I wouldn't be surprised if we see a lot more of this momentum happening. And while these are serious challenges, this is the time to lean in to education change. It's not time to withdraw. We have an incredible opportunity in our country right now to really see some change and accelerate that change and to help usher in a better future for our kids. That's what motivates me. We don't want to miss that opportunity. And the Supreme Court is getting involved. It's changing. I think it's changing. It's jurisprudence a little bit, which is having an effect in this area of education. And I did teach constitutional law at Patrick Henry College for a number of years. And I would always start, well, not usually start right off the bat, but I would often start off with talking about this idea of constitutional law. And I would go like this, constitutional law. And they'd be like, what? What do you mean? And, Professor Leo Graglia at the UT, he talked about this, and I kind of agree with him. I would point to them and I say, well, show me where it says law on the top of a Supreme Court opinion. It says opinion. Is that law? Where do we find law? Well, last time I checked, Article 1 said all legislative power granted under the Constitution of the United States is granted to the Congress. So we would have a conversation about separation of power. What is law? What is an opinion versus law? But we're here to talk about this question presented. Are religious charter schools protected or prohibited by the First Amendment? I was going to say religious schools, religious charter schools. There's 4 cases I just want to review because I don't assume everybody is like into this like we are, okay? Like we're into this. But 2017, I'll just start there. Trinity Lutheran, right? the school heard about this program. Hey, schools can get these chips or rubber chips for playgrounds, and they apply. And Mississippi's like, nope, sorry, you're a religious school. Was it Missouri? Sorry, Missouri. You're a religious school. We can't give you stuff. And the Supreme Court said in a 7-2, I think it was 7-2 decision, said that is odious to the U.S. Constitution. This is when Lemon was still alive, I think, sort of alive. So Trinity Lutheran, Espinoza, a few years later, Montana case. It was a scholarship program which gave donors a tax credit for giving private money to a scholarship program, and there was a rule that prevented the recipients of that money from using those funds to pay for private religious school tuition. And the court said that violates the free exercise rights of these recipients and is not an establishment of religion. A couple years later, Carson v. Macon, the court said, hey, Maine, you have this town tuitioning program. You let kids in towns where there are no schools choose, their parents choose, if they want their kids to go to a school somewhere else. You cannot prevent them from choosing a religious school. That violates free exercise, their free exercise. And let's not forget Kennedy v. Bremerton, where Justice Gorsuch reminded us that Lemon is no more, right?
Long since abandoned.
Abandoned, thank you. Long since abandoned. Out with subjective three-prong purpose, effects, entanglement, right? And in with history and tradition. Town of Greece v. Galway. So in case anybody wondered about Lemon, just you heard it here, you didn't hear it anywhere else. Chief Justice Roberts wrote this in Espinoza. He said, a state need not subsidize private education. But once the state decides to do so, it cannot disqualify some private schools solely because they're religious. In his dissent in Espinoza, Justice Breyer asked, what about charter schools? Here we are. So let me introduce Nicole Stella Garnett, who is the John P. Murphy Foundation Professor of Law at the University of Notre Dame, a fellow of the Institute for Educational Initiatives, a senior policy advisor for the Alliance for Catholic Education. She had the amazing privilege, I'm jealous, of clerking for Justice Clarence Thomas. I couldn't do it, but God bless you for doing it. That's awesome. She is a fellow at the Manhattan Institute and has written many things, which you should read, some of which are in the folder that we gave you for CLE. You want to read as much of that as you can, okay? All right. Renita Thukral is the Senior National Advisor for Legal Affairs for the National Alliance for Public Charter Schools, has extensive experience with charter school associations, has taught as an adjunct professor at Loyola University in New Orleans, and before attending law school, actually taught in a school. Was it a charter school?
No.
It was a public school.
It's a private school.
It was a private school.
Yeah.
Actually was a teacher. That's cool. And serves on 3 nonprofit boards. The one I thought was really cool was the Global Charity Foundation, which is a United States-based nonprofit providing healthcare and education services to women and children in India. So I think that's really cool. And I just want to recognize Mr. Thukral, Renita's dad, who is here with us today. I'd be super proud if I was here, my daughter was up here doing that. So that's really cool. All right, so this is going to be interactive. I'm going to ask Nicole and Renita some questions, invite them to answer and respond to each other, and then hopefully we'll have time to get some insightful questions from you, our equally brilliant audience. Okay, so let's start with this. As lawyers, we got to define our terms, right? Shouldn't we do that? We should start with definitions. So Nicole, let's start with you. What is a charter school anyway?
Okay, so I have been teaching education law about 20 years. So I'm going to give the definition. I'm going to give 2 definitions. The first is the definition I would tell when I teach this, and the second maybe is the definition or the definitional difficulty that is underlying the issue that we're talking about here, which is about the intersection between the First Amendment Free Exercise and Establishment Clause and charter school laws that prohibit religious charter schools. So this is how I define charter schools to my students. One thing that's interesting, I was just telling Renita, is I'm now at a point in teaching where most of my students know what a charter school is. That wouldn't have been true 10 years ago. It was about 5 years ago that I had my first student who had in law school who had attended a charter school. But 5 years, even 5 years ago, they wouldn't have known the difference between a voucher and a charter. But the way I would define, when I spend a whole day on charter schools, and I define them in the following way. So charter schools are privately operated schools that are designated as public schools by all states. Most of them are operated by nonprofits. A few states allow for-profits to operate them. They must, by law, be secular schools. That is to say, they may not be religious in their content or their programming, but and in most states, they may not be religiously affiliated. Even a secular school may not be religiously affiliated. A few states allow religiously affiliated charter schools as long as the school is secular. So charter schools are created as a contract between a private operator and a charter school authorizer. Charter school authorizers are designated by law, and who they are depends on the state. School districts, I think in every state, are authorizers. State education departments in many states are authorizers. Some states have special commissions that authorize. Some states allow nonprofits to authorize, including, interestingly, religious nonprofits can be authorized in a couple of states, universities, private universities. And charter schools are freed from compliance with many, but not all, of the regulations that govern district public schools, the things that I grew up calling public schools, that were run by the government, in order to promote educational pluralism, although the extent of that regulation varies by state, which is something we'll get into. The first charter school law was enacted in 1991 in Minnesota, exactly 1 year after the first voucher law. So I tell my students, and when I graduated from high school in 1988, there was no such thing as a charter school, right? There were a few magnet schools, there were no vouchers. If your choices were mostly move to public school district or pay for private school tuition. Okay, so that's how I would define charter schools at the beginning of an education law section on charter schools. I think, though, for purposes here, there's a different definitional complexity. So if we're asking what charter schools are for purposes of this question, we might have to ask not what are they under state law, but what are they for purposes of the federal Constitution.
So before we get there, because
Yes.
that is where we're going.
Okay.
Let's give Renita a chance to. That was a long definition. Renita, what's your definition?
Hi, Mike.
And help us understand if there are any differences.
Well, first I want to say thank you for having us. We're very happy to be here. We have a teammate from the National Alliance are here, so thank you guys for being here as well. It's an honor to be here and be able to talk about this with you all. We have been following and working on this issue and others related to it probably since 2016, when the Peltier case, which is also in your materials, was first reaching headlines and being litigated. So when we talk about this issue, we bring 7 or 8 years worth of study to it, and we're excited to bring it to you now. My definition.
Okay, you said a case.
Yes. Oh.
So we have to tell the people what the case is about.
Oh, don't worry. We'll be talking a lot.
We're going to talk about
that
it.
case.
Okay.
Oh,
okay.
yeah.
All right.
A lot. I apologize.
Sorry,
for
back to
how
the
much we're
definition.
gonna
Go
talk
ahead.
about it. All right. So the definition. Mine is maybe a little bit simpler. Not that I disagree with any of what Nicole just said. It's all accurate. We think about charter schools as public schools. First and foremost, they are public schools. Every charter school is defined as a public school in state statute and in federal law. We define charter schools to be schools of choice. Parents and families choose these schools. No one is assigned. These schools are part of every state's public education system. And as part of every state's public education system, they help the state fulfill the state's education clause obligation. These schools are governed by volunteers who oversee the operation of the school. And I sequenced it in that way because that is how we think of the schools. Schools first, public schools always, and overseen by a nonprofit governing board, all volunteers, who just make sure the terms of the contract are satisfied. The school and the board are held accountable by a performance contract. That contract runs to the state, and there are annual reviews in some places and always 5 and 10 year renewals, or somewhere between 5 and 10 years for states to be renewed. Right? So that's a very active participation and partnership between the governing board and the state to keep the public school in operation.
Okay, so Nicole, you were about to start telling us that there are these different purposes that we define things, but I just want to give you an opportunity. Any issues, concerns, observations about what Renita said in terms of how she defined the schools, the charter schools?
Well, I'm not allowed to talk about the alternative, what the
You can
definition.
talk. You can say whatever you want. We're free speech here, right?
I mean, I don't disagree with the words. No, I agree with all the things that you said. I mean, I think, public school is what they are called in state law. So I don't object to that definition. they're different than the public schools that I went to in the Blue Valley School District in suburban Kansas City. What are they for purpose of the conversation here, though, is a different legal question. And that is, are they government schools, or whether, technically speaking, and then you can talk about Peltier, whether or not they're state actors. Because as we all know, because most of you, I assume, are lawyers, the Constitution binds usually the government only, and the government and private actors only in the extremely narrow circumstances that the private actor is so closely controlled by the government or intertwined with the government that the private actor's actions are the government's actions. So the question, I think, for purposes of this conversation is, are charter schools state actors? That is to say, are the actions of the school, the government's actions, in which case they are bound by the Establishment Clause, or are they government contractors? Because government contractors are typically not bound by the Constitution. Lockheed Martin makes a lot of stuff, I hear, for our government, and and it's not the government, and it's not bound by the Constitution. So is a charter school a state actor, in which case it's bound by the Establishment Clause, or is it a private school? Now, it can be a privately operated public school that gets called a public school. I don't have any problem with definitions like that. The word public is not talismanic. It's not the question, right? Public utilities, by and large in this country, are not state actors. They're not the government. So we have, the word public doesn't have any particular constitutional meaning. And the reason this matters, obviously, is because if the schools are state actors, then probably, we could fight about Kennedy, but I'm sticking to it, government schools have to be secular schools, even after Kennedy. I'm going to go out on a limb and just be radical and say, yes, we're not going to bring back religious public schools if they're state actors, but if they're not, then the Carson and Espinoza rule that you just articulated applies. The state need not subsidize private education, but once it chooses to do so, it may not refuse to subsidize religious private education. So that's the definition, I think, not what the state calls them, but what they are, that's relevant.
What the Supreme Court calls them.
Well, I mean,
whether they're state actors or not, ultimately, right?
What the doctrine calls,
Right.
what the state action doctrine would find them to be. Right. And it's a very complicated doctrine, and it's developed and developing, but yeah, so it's not what the Supreme Court calls them, it's what they are under the state action doctrine.
Well, right, and what I was simply getting at, Nicole, was eventually the Supreme Court is going to be called on to make this decision about whether these things are or are not state actors, and that's Peltier. You want to just help
Jump
us out
right
here?
in.
And also, yeah, just react to whatever Nicole had to say.
Yeah, I mean, at the end of the day, I very much appreciate the way Nicole frames the issue because we agree with it, right? The question is whether or not public charter schools are state actors or not. And so put another way, the question is whether you can have a non-state actor public school, which if you take a second to think about it, has never existed before. All traditional public schools are always state actors, they always have been, and I think we agree they always will be. And so the question becomes whether or not a 501c3 public school, right, that is what charter schools are. Whether or not
Are there some non-501c3 charters?
That's a good point. I mean, it's a nonprofit public school. The vast majority seek tax exemption just for their own
But
purposes.
there are for-profit
In one
EVOs.
state, there is a for-profit entity that can hold charter schools. That's in Arizona. It is true that
Oklahoma allows for-profit charter schools, as does, I believe, South Carolina.
So you're allowed to contract out your operations to
I see.
a for-profit management company, and then I think in more than just those states. So that absolutely is part of the sector, but the entity that holds the charter, that is granted the authority to operate, is a nonprofit in every state except for Arizona, where there are a very small number, like count on one hand, operators that have for-profit corporate status. So for the most part, you have 501c3 public schools, and the question is, how do charter schools have it both ways, right? Like, we just want to acknowledge that we get it. A 501c3 public school, is it public, is it private? Like, what the heck is that, right? And we sort of joke, and I think my colleagues from the National Alliance will chuckle, like, if it walks like a duck and it quacks like a duck, is it a duck? And we're always like, no, it's a chicken. It's a chicken who knows that being a duck is sometimes advantageous, right? And so at the end of the day, right, Are charter schools 501c3s for the most part? Yes, right? I think that's there, but they don't operate like your standard nonprofit, and we're going to talk about why in a second. Are they public schools? Yes, and to Nicole's point, they do not operate like traditional public schools, right? And just because they're governmental entities, right, for some purposes, they are not governmental entities for all purposes. By no means do we think that just because you are a state actor for purposes of the federal Constitution, that you are always a governmental actor. And we bring you this because we have been studying it for many years. It is probably the most important legal question that we confront at the National Alliance. And I've been with the National Alliance for 13 years and then working the sector before that for another 7. This is the question that we ask over and over and over again.
Just
So-
for me, because I'm a
yeah.
little slow. What's
Yeah.
the question again?
That's a good question. How can charter schools have it both ways?
How can they both
Be
be
public
public
and private,
at
and
the
what does that
same
mean?
time? Okay, thank you.
And sort of
Just
what does it
wondering.
look like, right?
Okay.
I mean, and let's just start off by some of the things that Mike started off with, right? Whatever it is, it's working, right? We have 3.7 million students in charter schools in 45 states and the District of Columbia, Guam, and Puerto Rico. They are attending schools on 7,800 schools and campuses across those jurisdictions, right? So this crazy arrangement is working. Schools are innovating, schools are growing, parents and families are choosing to attend. All right, so here are some features of publicness that we think are important, and I want you to think about these in the context of a nonprofit, right? A nonprofit school. These are tuition-free schools, open enrollment. You can't pick and choose your students. Anyone who wants to attend can, as long as there's space. If there isn't space, you run a blind lottery. There are non-discrimination requirements. All charter schools are subject to all federal and state civil rights laws. Some charter statutes require charters to provide the same constitutional rights to their students as traditional districts provide theirs. This is in statute in some places. There are no academic tests to enter a charter school, with very rare exceptions. Teachers are either permitted or required to participate in state retirement systems in all states but one. I think Montana is the exception. We'll talk to Christian about that later. Teachers must be certified or working towards their certification in many states. Teachers can unionize, and sort of interestingly, in some places under state labor law. These schools must meet or exceed the same academic accountability standards as district schools, standard established by the state. Schools are funded through the per pupil formula, for the most part, not through a line item in the annual state budgets, as most private school choice programs are. Schools typically have to submit annual financial audits conducted by a third party to the state. This is where it gets even more interesting. Schools must comply with open meetings laws, public records requests, and the nonprofit boards must comply with open meetings laws. Right? Board members in many states are deemed public officials by statute. Board members in some states must abide by the same financial disclosure requirements as elected officials. Board members in many states are subject to their state's ethics commission rules. Board members in some states have to take oaths of office to be on the board. And board members in some states can be removed by the state, and new members can be appointed by the state. Knowing this, do you want to be on a charter school board? It's not your standard nonprofit board experience.
So you're making the case that they're state actors, I think.
I'm making the case
Right.
that as a 501c3,
Yeah.
you're not operating with the independence of most nonprofit boards. And you
Okay.
are heavily entwined with the state.
So let's talk about
Yes.
Peltier, or
Yes.
is this, you think it's a good place to just talk
Yeah,
about Peltier and what's going on?
Can I just respond really
Please- no,
quickly?
please, respond,
So it's really
yeah.
important to keep in mind, the state action doctrine is complex, but, so you can be a state actor for some purposes and not others. And I would be the first to say that the state action question is more, there are some states where it is pretty easy to say that charter schools aren't state actors, and in some states, because they're so closely controlled by the government, I think it would be harder to make the case. Though I might make it, but I mean, I just think we have to recognize two things. It's not what, this is to your question about will the Supreme Court decide? It's not one question, are charter schools state actors or not? It's, are charter schools in X state for purposes of, you pick, employment, curriculums, state actors. Most of the things, on the state action doctrine, most of the things that you just listed, I'm just curious what you think makes it a state actor and for what purposes, because most of those things, I think you could apply those regulations to private schools. Private schools would kick and scream, but they wouldn't become the government, right? You could say you have to, St. Joe Grade School has to comply with open meetings laws, and Father Matt would be very angry about that. But I don't think, and he might sue and say it violates his First Amendment rights. I don't know if it would, but I don't think that makes him the government. So a lot of being, what you're describing is distinct rules applied to certain kind of private nonprofit, but I'm curious, like, which of those things you think makes the charter school a government actor for purposes of what?
No, that's a great question, and we didn't rehearse this. I feel like that's the exact way to talk about Peltier, right? I mean, in Peltier, so I'm going to give a quick background and then we'll just jump into your question. In Peltier, right, this is a case that came out of North Carolina where the charter school was running a dress code that required girls to wear skirts and dresses and skirts and required boys to wear pants and shorts. And as we all know, public schools and private schools, but for these purposes, public schools can have gender or sex-specific dress codes. They just have to satisfy the equal protection test that applies and or whatever Title IX standards apply, right? So it's not that you can't have them, it's just that you have to be able to explain them appropriately. This particular charter school leader said that their school, as part of its classical curriculum and pedagogy, believed that the dress code imparted a culture of chivalry, which was important to that school. And as part of the culture of chivalry, it believed that girls needed to be treated as fragile vessels, this is in depositions, and as fragile vessels, boys needed to learn to protect them and be chivalrous and honor them, and the dress code was essential to that. I just gonna zoom out for a hot minute. Every court that considered the question of whether or not that dress code violates the Equal Protection Clause said yes, it does, right? So the question, and to Nicole's point, is whether or not the Equal Protection Clause even applied in that place, in that particular school. Because if it did, that dress code, it doesn't work. If the charter school was not a state actor, then you revert to different questions about Title IX and so forth. So in that case, it was litigated for many years. Trial court, first a 3-judge panel in the Fourth Circuit, then an en banc panel in the Fourth Circuit. So in June of 22, an en banc panel of the Fourth Circuit issued a 9-6 opinion, I believe on entirely partisan lines, where the Democratic majority concluded that the North Carolina charter school and all North Carolina charter schools are state actors for purposes of the 14th Amendment's Equal Protection Clause. Right? So to Nicole's point, it was a narrow inquiry that concluded that this particular dress code was improper because the school, like all North Carolina charter schools, were state actors.
So can I just point out one little thing on that, because I think it's
Yeah.
important? If I'm remembering correctly,
Yeah.
the legislature of North Carolina and the Supreme Court of North Carolina
Yeah.
said that the charter school was not a state actor.
The trial court said that it
It
was.
wasn't
Yeah.
in state court.
Wasn't state,
It was
federal?
federal court.
Yeah,
Okay.
And the 3-judge panel,
Yes.
2-1 said it was not.
yes,
And then there was a divided en banc panel.
Okay. That was,
yes. And so to Nicole's question about what elements that I just sort of rattled off and like which of those make the most difference, you know, the en banc majority in Peltier used a totality of the circumstances test. It combined various features of the state actor doctrines test, right? It used the public function test. It relied on the constitutional delegation test. It did not really speak too much about the entwinement test, but it used these factors and kind of cabined it all as totality of the circumstances. And I think the one that was most persuasive to me, and I think for those of us who do this work, is the way in which that en banc majority characterized our work, right? It said that the North Carolina Education Clause requires the state to provide a free public education, that the North Carolina legislature chose to partially fulfill that duty under the Education Clause by enacting the charter statute. And therefore, public charter schools in North Carolina, by helping the state fulfill its constitutional obligation under the Education Clause, are state actors, right? So it's a combination of the way in which the statute emanates from the Education Clause, it's funded through appropriations permitted by the Education Clause, and it is required to be under the supervision and control of the State Board of Ed, also because of elements of the Education Clause.
Yes, please, Nicole.
So, not surprisingly, I filed a brief in support of cert in the Peltier case. The court denied cert. I was a little surprised. They did if you're a lawyer, they CVSG'd the case. They called for the views of the Solicitor General, so there was a lot of chatter that maybe they would take the case. And I'm going to just go out on a limb and say if they had taken the case, it would be to have corrected the gross error of the Fourth Circuit, leaving aside the charter school problem. The interpretation of the state action doctrine by those six judges, that en banc, was awful, because it would have turned, okay, so your point about, so one of the things it said was, there's these different tests, like, is it a traditional state function? Well, education can't be a state traditional function. We've got 10% of the kids in the United States going to private schools. Is there entwinement? I don't know what that means. Is basically the school acting as the government's agent. What the Fourth Circuit said was, look, the North Carolina Constitution requires the state to provide education, and it's contracting out part of its obligation to these charter schools, so therefore they must be state actors. Think about the implications of that. The state of North Carolina has a voucher law. Are the schools that participate in the voucher program state actors? Absolutely not. Funding is not, the court has made clear, funding does not turn you into a state actor. Regulation doesn't turn you into a state actor. In the brief that we filed, the Notre Dame Religious Liberty Clinic in this case, we pointed out that many states have obligations to do other things in their constitutions, provide health care, provide housing. So if this would actually threaten, that interpretation of the state action doctrine would turn lots of religious nonprofits into state actors in states that required the state to provide housing, I don't know, like the Salvation Army.
Adoption services, right?
Adoption
Fulton County.
services. So I think, like, the interpretation of the state action doctrine in that case, I think, was flawed. And already in the Fourth Circuit, we're getting low off, but I've been following. Already in the Fourth Circuit, the Fourth Circuit has relied on Peltier to hold that a private adoption agency is a state actor. It was bad law. It was a bad case, but it definitely squarely addressed this question: are the charter schools state actors? I think they got the answer wrong, but I think they just got the law wrong.
This is important because this issue is not going away, okay? And we're not going to talk about the case in Oklahoma because the parties on the stage are parties in the case in some way, shape, or form. Oh, Renita's
I'm not a party in the case.
Well, not a party, but you're, what are you? You're something.
I'm a lawyer.
You can't talk about it because you have an obligation of some kind, some ethical duty or something. Anyway, but in Oklahoma, and the materials are in the folder for your CLE, you've got interesting thing happen, so the Attorney General Connor wrote this long opinion saying, we must issue charters to religious schools in Oklahoma because the Supreme Court under Trinity Lutheran Carsey Macon Espinoza says we have to. And then Attorney General Gentner Drummond said, no, we're not doing that. He withdrew the opinion. Okay, then a Catholic entity applied for a charter, was granted a charter. There's litigation. So whether this case makes it to the Supreme Court or not, this issue is probably not going away. But, question, so what? So what does it matter? I mean, is this a good thing, a bad thing? Do we want charter schools to be able to be religious? I mean, you said well, I guess it begs the question, what are charter schools? You said you don't want public schools to be religious schools, but if charter schools, as Renita says...
What I said is that government can't be religious. You've got traditional public schools, district public schools are run by the government. Right.
So if it's run by a religious entity, even though it's paid for under the charter statute, that's okay. You would say that's okay. They can be religious. Charter school can be religious.
In most states, I think the state has to let them be religious. I mean, can we talk about Guam instead?
Let's talk about Guam.
We
Same
can talk
thing,
about Guam.
same issue.
Guam is the only state, well, it's not a state, it's obviously not a state, I know that. I'm a lawyer.
It's like a state.
Interesting, and Guam recently became the first governmental entity in the United States of America to authorize religious charter schools. And it was very interesting. The legislature passed a law authorizing religious charter schools. The governor vetoed the law on constitutional grounds, saying it was unconstitutional to allow religious charter schools. The Attorney General of Guam, I'm proud to say, is a graduate of the University of Notre Dame, issued a letter, like John O'Connor's letter, saying, no, look, you really have to overturn the governor's veto because the First Amendment requires the authorization of religious charter schools, and they did. So Guam has authorized religious charter schools. There's a total of 7 charter schools permitted in Guam, but we actually understand that, I think you told me, that a Catholic school is applied to become a charter school in Guam. So is it a good thing? Is it a bad thing? I think for me, I've been kicking this anthill for even longer, thinking about this. I think my first time I wrote about this was 2012 in an article called Are Charters Enough Choice? For me, it's fundamentally, I think it's unconstitutional, but it's also fundamentally unjust to say in a state without private school choice, look, if you wanted money, government money, that's fine, we'll give it to you, but you have to give up your religious identity. That's the deal. I just think that's unconstitutional, it's unjust. Is it a good or a bad thing? I think, well, look, I mean, should religious organizations choose to go down this path, like the Archdiocese of Oklahoma City and the Diocese of Tulsa have? Well, they're grown-ups, they can decide. They can decide whether it's the thing that they need. In Oklahoma, they decided that they wanted to be able to serve more rural kids through a virtual charter school. That should be their decision. That is what Carson and Espinoza stand for. Some religious organizations will say, no, I don't want to do that. We prefer to do an ESA. We prefer to privately fund. So it's a question of whether it's a good or a bad thing, I think, is up to the schools themselves to decide. And the constitutional religious liberty question is a different question.
What do you think, Renita?
Well,
You have a different point of view on that?
I might have a different point of view on that. And I think it's a complicated question with a lot of fallout. All right, so can we go to Guam just for a second? When we first heard about Guam, we were like, wait, what is happening right now? And so it does turn out that everything Nicole said is true. And what we learned when we spoke with folks on the ground in Guam is that the private religious school that is in the process of converting to a charter school in Guam is actually decided to be non-sectarian. So they have submitted an application that says it will not be religious in its teaching or character. So that was sort of an interesting twist. We weren't expecting it to go that way.
So it was religious, and then it now is saying it's not going to be religious.
Yes, in its application that was
Interesting.
pending
Okay.
before the authorizing board.
Why?
We didn't, we actually reached out to that school leader on several different occasions, and we didn't hear back, but what we were told is that the families would continue with the school without the religious character. We don't know directly. It's just what's happening. In terms of, is this good or bad? I think I wanted to offer one distinction about the government contractor angle, and then also give a little bit of information about some recent cases that give you a sense of where schools are on this.
And then we'd like to get your
Yes.
questions, because is anybody
Yes.
else's head spinning? I don't know, maybe you guys are smarter than me, but I'm trying to figure this out. So get your questions ready, be very short and to the point if you can be. Thanks.
Okay, so quickly. The government contractor construct is understandable, right? Nonprofit, it gets a contract with the government to provide education. Sounds like a government contractor. What's unique to us about the charter model is that, Renita's charter school, if I lose my contract with the government, I cannot still operate. I can't get revenue in any other way. My sole purpose is to exist as the charter school that comes to life with the contract or the charter contract that I have with the state. So it's not a typical contractor or government contractor arrangement where you can lose one contract but continue operating in other ways. That's simply not how the charter model works. And so I just think it's an important fact and a distinguishing, and we think really important
But you could
distinguishing
open
fact.
as a private school.
Yeah, you can absolutely reconstitute, change your 501c3 status, explain all the reasons why, and then change the way in which you operate. But as a private school, you're not getting
The private schools are often 501c3s.
No, but like
right?
your 1023 would say that you're gonna, when we help schools submit their 1023s, they say they're gonna be a charter school, they get a special kind of supporting org status, and they go on and go forth. And then, you
This
know,
is under the federal income tax code. There's actually a recognition of charters.
no, just of a
okay.
supporting organization in order to get your C3 status, so that, it's not something that private schools don't do, it's just that when you provide when you are coming to life and you're incorporating documents in your tax documents, you are very clear that your sole purpose is to be a charter school, right? You can lose your charter, you can repurpose your C3, and then you can go about and do something else, but you're no longer Renita's charter school, right? And there are nonprofits that offer wraparound services, and one of those services is a separately constituted charter school. They could lose their charter and continue being the wraparound services they previously were, right? But they're no longer providing public education without their charter, right? In terms of where this is good or bad for, let's say, charter schools, right? There are 3 very innovative networks that have litigated this question recently. Success Academy in 2018 in New York City. You guys may have heard of Success, incredibly innovative, maybe the largest operator in all of New York City. Lots and lots of students. They were facing a Section 1983 claim, right, which is only something that state actors face, on a due process issue related to long-term suspensions. And they simply conceded that they were state actors. They didn't even litigate it. The court handled it in a footnote, said, of course you're state actors, this is federal district court in 2018, and then went on to the merits, right? Just last year, Democracy Prep, a national network operating in 5 or 6 states, was in federal court, also facing 1983 claims related to alleged violations of a student's First and 14th Amendment rights. This is in Las Vegas. And they too conceded that they were state actors and then went on to litigate on the merits. And right now, in Colorado Springs, there is a charter school called the Rocky Mountain Classical Academy that is litigating an equal protection dress code case. They just had oral argument in the 10th Circuit in May, and they too conceded that they were state actors and went on to the merits. In that 10th Circuit case, my understanding is that the federal district court actually queried, hey guys, you know, this Peltier thing is going on. Are you sure you want to be a state actor? And the Classical Academy in Colorado Springs said yes. Right? So I want to raise this because I think it's an important piece of the pie to just understand that Section 1983 liability is not stifling innovation. It is not stopping growth. It has always been a feature of the way in which charter schools operate. And it's not something that schools are afraid of. We don't see a lot of litigation on this because schools are fine with the state actor status. I think that's an important piece just for everyone to consider.
Although
Wanna put a point on
obviously
that?
in Peltier, the charter school did not concede. Ninth Circuit has, there's a split on the issue, on the big issue. The Ninth Circuit has an opinion saying the charter school in Arizona was not a state actor for purposes of I think it was a due process teacher firing case.
Yes.
It was some years ago. So, I mean, like, conceding that I'm happy to be sued for something that I might not need to be sued for doesn't change the existential sort of underlying question about whether or not, you know, Democracy Prep is in fact a state actor or not. And one last thing about Peltier, I mean, I do agree with you that this is not going away. 10 states filed a brief, 10 AGs filed a brief in the Peltier case, basically saying charter schools in our state is not a state actor, and we are concerned that the opinion in the Fourth Circuit, if that interpretation of the state action doctrine as applied to charter schools spread, that it would undermine innovation. It was led by Texas. One funny thing about that is one of the states on the brief was Nebraska,
Yeah,
and
it
they don't
doesn't
have
have
charter
any.
schools, but
Yeah.
So,
And
so,
looking
Kansas
ahead.
has just a couple.
so get your questions ready. Start queuing
Yes.
up at the microphones if you can even formulate a question at this point. This is not just in education, by the way. This extends beyond, well, whether our charter schools can or not be religious, but it also goes into whether teachers can participate in pension plans, because that's North Dakota. AG opinion in North Dakota says private religious schools or charter schools or whatever, they, my point is that it extends beyond merely this question of whether a religious charter school is protected or prohibited by the First Amendment. And I think the answer is you would say prohibited and you say protected. Yes? Religious charter schools.
I say protected.
Protected and you say prohibited.
Yes.
Okay. Well, we are honored to have Mr. Senior Counsel Jordan Lawrence with the Alliance Defending Freedom asking a question.
So I just want to say that this is hard for me to wrap my head around. So I just want to admit that, even though I've been litigating for many years. So I want to ask, and maybe you've sort of answered this, but I need it again. It seems to me that when they were doing charter school legislation, they weren't thinking about this. And then how the laws happen to flop on one side or the other is where the litigation is going. So I want to ask more of the public policy question. Is it advantageous to have charter schools be public state actors, or is it better to have them be, kind of voucher recipient private schools? And I'm trying to understand what's going on here rather than what the legislation, when it gets up to a court, like at the 4th Circuit or the 10th Circuit. So I hope this is making sense, and maybe you can kind of, because it still seems sort of fish nor fowl to me.
Are you asking whether it's good or bad?
Yeah. What do we want to do? Do we want to make this more distinct, or
I think
not?
I asked that question too, and I'm not sure we got a particular answer to it.
Yeah, maybe one of the ways to think about it is when charter schools, I think in part were a way, and I'm not blaming Renita for this, but early on, advocates in state legislatures saw charter schools as a way to ward off vouchers, right? So they were distinct, that was one advocacy strategy. But I think, good or bad, I'm a both and kind of person. I think that the question of whether charter schools are a good thing or a bad thing is distinct from whether or not we have ESAs and vouchers and tax credits. I'm bring it all on. I'm all for maximizing choice. I think charter schools have become much more regulated over time in a way that, as an advocate for educational pluralism, concerns me. Not so much in states like Oklahoma, but in others. So good or bad, it's also just a question of how, right? So how do we structure these things? And how much freedom and how much pluralism? I would like to maximize educational pluralism, and so therefore I would maximize education freedom, both in the charter sector and in the private school sector.
And I would say that I'm not sure the answer to this question necessarily impacts whether we can have all these other things. We could have a situation where religious charter schools are not allowed, but we can still have lots of different other approaches to giving parents more choices. Renita, you have a good answer for Jordan?
We actually have been working on this. There's an entity called the Founders Library. It's hosted by the National Charter Schools Institute. It's actually a catalog of lawmakers in various states who were among the founders of their charter school statutes, right? And so we actually had the opportunity to hear an interview of the North Carolina lawmaker, Speaker Brubaker, who was the one who got the North Carolina charter passed. And he basically, in his interview, said, listen, they're intended to be public schools. We had the opportunity to build a voucher program at that time. And to Nicole's point, it wasn't so much a compromise as a pivot, right, away from providing private school choice and instead creating public school choice with everything that meant. That I agree with you. I don't think lawmakers were thinking about the state actor question when all this was coming about, but I don't think that's because they didn't want kids in charter schools to have their federal constitutional rights. I think it's because they thought it was obvious that when you are part of the public education system in a state, that you are not allowed, for instance, to be religious or to impose a discriminatory sex-based dress code.
So, Michael, can I just ask one follow-up?
Jordan,
Okay.
we only have 9 minutes left. Counselor, I'm sorry, your time is over. I apologize. And I love that man. He is amazing. Ms. Gentiles, please, you have a question.
Yeah, Jenny Gentiles with Independent Women's Forum. I actually had a similar question. I understand Catholic entities in Oklahoma perhaps being interested in wanting to serve more students and therefore looking for options. Now we have a private school choice program in the universal tax credit. in the state. So I wonder if you all would recommend that that these entities who want to serve more students go that route. I do think that's an important thing for everybody here to consider when they're advising clients. The question that I'll ask instead, though, is I know that the National Alliance asks for or advocates for the charter school program, the massive pot of federal funding that helps with startup funds. Are you all going to specifically recommend blocking funding from going to a faith-based Catholic entity? It sounds like you're very opposed to this idea. So will you be blocking funding or advocating against these organizations?
You know, it's a great question. I believe that the department back in 20, after the Espinoza decision, so I think in December of 2020, the CSP office, guided I think by the Office of Legal Counsel at USED, made it clear that you could not discriminate in the allocation of CSP monies based on religious affiliation. So it's not really even an open question. So in Oklahoma right now, right, they have a CSP grant, but the way that was applied for by those who applied and then obtained it, it's not available to any virtual charter school, right? So, you know, we don't get involved in how the applicants seek the funding. And the department has already made it clear that you cannot discriminate based on faith affiliation.
Right, but there's a difference between faith affiliation and being a religious school. So I think that I've talked to Renita. I think she and I agree that it would be it may be unconstitutional. We may agree that it is unconstitutional to prohibit religiously affiliated charter schools, and that was what that was about. But it's clear they have to be non-sectarian in their operation. So, and as a Catholic school person, as someone who sends my kids to Catholic school, like if you just say Catholic in name only, that's not Catholic. I mean, that's Carson, right? Like it doesn't. There's no distinction between discriminating on the basis of religious status or affiliation and discriminating on the basis of religious use or being Catholic, Muslim, Jewish. And whether it's a good idea or a bad idea, Jen Daniels can answer that question for you later. She works for the USCCB.
Mr. Adam Kissel with the Cardinal Institute in West Virginia.
Yeah, but also I'm the chairman of the board that authorizes charter schools in West Virginia.
Even more important.
And my job is to interpret the West Virginia law exactly on this issue and many others. And so I even tell applicants that you're a public institution or going to be one, so you have to tell me from the beginning that you're not going to violate the First Amendment, and I make sure that their application is First Amendment compliant, for instance. But my question really then is your difference of opinion about current law or about in principle whether a state could contract for educational services, and from that point of view, if it writes its law correctly, in principle, it could also charter private entities, including religious ones? Or is your difference of opinion really it's about current law? Does current law allow it? Because current law in West Virginia totally does not allow it.
So I think that's a great question, but my answer to you is if it could, then it must. I mean, if this, that's what Carson and Espinoza says. If you could include religious schools in these programs, then the laws that exclude them are unconstitutional. And so, like, if what Guam just did is constitutional, and I think it is, then I think that what West Virginia is doing is unconstitutional. Although I haven't studied, again, with the caveats that the state action doctrine is complex, and I don't know how you regulate your charter schools. And also, you can tell charter schools, like as a condition of participating, you have to agree to comply with what the Supreme Court doctrine on First Amendment is, and I don't think that makes you a state actor. That's just the law, and then you could fight about, they could sue you if they think that's wrong, or it violates their rights. But I think you're asking a great question, but I mean, what the Espinoza-Carson line of cases suggests is Justice Breyer says, what happens when can becomes must? And that's the way I would answer your question.
Again, I mostly agree with Nicole. I do think it's an important question to be asking. The one thing that I keep coming back to is whether or not the opportunity to run a charter school is akin to a government benefit. I mean, a government benefit means something very specific in Trinity, Espinoza, and Carson. It's not the opportunity to run a school that will be funded with public dollars, right? It's just a stretch. And I do know that there is a pending case in Colorado that doesn't discuss the specific thing. It's the challenge to the universal pre-K program there, where one of the challenges made is that the effect of excluding religious entities from participating in the program violates Carson. And so we may get some additional clarity on how broadly government benefit is defined, but right now, benefit is pretty narrow.
$12,000 a kid is a pretty big government benefit.
But
I mean,
it's-
how is that not a government benefit? If you open a charter school, you get $12,000 a kid.
Oh.
If you don't open the charter school, you don't.
Only if the parent chooses your school, right?
Sure, but in Indiana, if you send a kid to St. Joe grade school, you get, what, $7,500 now? I'm looking at you. And if you send your kid to a charter school, you get 12. I mean, they're both government benefits, and just one gets more. I mean,
We have a difference of opinion, and that's okay. Mr. Peter Murphy, identify yourself however you want.
A friend of Mike.
I'll take that. But you also are behind
With,
this federal tax credit program
Correct,
thing, right?
on
Yeah.
the private school side. So forget about charters, just help us. So, no, I was in charters in New York for a while, and, you know, the conferences, you guys held the national conferences, and everybody was a public school. Like, there was never
Yeah.
a thought otherwise. And Nicole, you said something earlier about district-operated schools have an entanglement issue, and they have to comply and not be religious,
the
right?
government.
Correct. But, I mean, district is government. It's a political subdivision of the state in New York. That's how they call them. So I just never thought that charter schools, at least in New York, and I think this is pretty common, you indicated it was, that they are independent public schools that are not district operated, but they're still creatures of the legislature. The legislature passed laws that created them, as every other state has. And so how is that open? Because Zellman, and I'm not a lawyer, please don't confuse me with a lawyer, but Zellman didn't Zellman hang their hats on the fact that it's a parent deciding what to do with money? It was not a public decision. So isn't there?
Well, the parent decides to send the child to a charter school. So I think
But they're creatures. But the charter school is a
so every
creature
501
of the state.
every nonprofit corporation is a creature of the state. I mean, so I have a piece that I wrote for the Manhattan Institute that I think in some ways started a lot of this, but called Religious Charter Schools Legally Permissible, Constitutionally Required. And I actually addressed this issue. Does it matter that they are created by a special authorization process because they're different because the government's creating them? I just think, like all nonprofit corporations, all corporations are creatures of the state. That's what corporations are. And so I don't see why it's different. But
how is a charter school different from a
So
district-operated school?
you're going to get to have this conversation right after this. Do you have any closing final thoughts on that particular question, or you agree?
I agree.
Okay, you agree. We agree. We are going to end with agreement among our panelists, who are brilliant legal minds, beautiful panelists here. Thank you all for participating in this. I hope this was interesting and enjoyable for you. Please thank our panelists.
Come on, go figure, right?
Big thanks to Mike and Nicole and Renita for a great conversation. We'll have a quick break and meet back here at 2:45 for our third plenary session.
That's what we said.